Hello there and a very good Monday evening to you. I'm Sonali Vanigabadage. This is Face the Nation. Now, Sri Lanka is rapidly moving towards an era of accelerated development, and with it comes the promise of foreign direct investment to ensure that the country is competitive in the global stage. However, it is imperative then for professionals, for intellectuals, for the technocrats, for the bureaucrats to all work hand in hand with the state to ensure that the country is on the right path towards development. Now, the free trade agreement between Sri Lanka and Singapore, which was signed in January 2018, continues to make it to the headlines, continues to make it to conversation tables. Now, tonight on Face the Nation, we will attempt to weigh in on certain issues surrounding this agreement. Is it really controversial, or is it a non-controversial document that is just being sensationalized or is politically motivated? Now, what are the fears of the general public? If there are any fears, should not the fears of the general public then be allayed? In whom does the responsibility lie to ensure that the correct information is disseminated to the general public? Well, on Face the Nation tonight, we will try to do exactly that. For this purpose, we've invited a panel of guests joining us this evening. Mr. Kapila Pereira, he's the Secretary of the Professionals National Front. Good evening and welcome to you.
Good evening.
We are also joined by architect D.H. Wijewardena, President of the Sri Lanka Institute of Architects. Good evening to you. Also joining us on Face the Nation is Mr. Sunil Aberatna, Attorney at Law, representing the Bar Association of Sri Lanka. Good evening to you.
Good evening.
Also, Engineer Dr. Anand Ranasinghe, who's the past President and Council, Institution of Engineers of Sri Lanka. Good evening.
Good evening.
And finally, Mr. Kitmina Hevage, Research Officer at the Institute of Policy Studies. Thank you for joining us. My first question is to Mr. Kapila Pereira, Secretary of the Professionals National Front. What is your main contention with this free trade agreement between Sri Lanka and Singapore? Are you not pleased that the government is moving towards ensuring that Sri Lanka is more competitive in the global market?
Yeah, before coming to this agreement, we were saying that the government is not adhering to the good governance practices, and they are away from all the major pillars of good governance like accountability, transparency, or the collaboration. Nothing was there. So we were very worried, and we asked to not to sign this agreement, and we wrote to all the cabinet ministers just before the cabinet approval in January at the beginning, but still they signed this during a politically unstable period when the elections were going on. And after that, it is really clear. Now the agreement is there on the table. Now they have opened the services to Singapore, and not only to the citizens of Singapore, but for the PR holders. And in Singapore, there is a special program to bring the entrepreneurs and investors as PR holders. So there's a special program there. So any other national can get this PR from there other than the other options to get the PR. So that means we have opened the investment segment for any country, because you can get the PR through Singapore and come here through this agreement. Then the next thing is, we have opened this for the services horizontally without considering all the segments or all the industries, and they have opened this for natural persons to move from Singapore to Sri Lanka up to 5 years visa, and they can come if they have a work permit. This is not for the this is not about the PR. This is about the work permit. If they have a work permit, then they can come here. So then there aren't any other restrictions from the vertical commitments. So that means that now it is open for services, and any other national can come here if they have a work permit in Singapore, if they get a work permit in Singapore.
Mr. Pereira, we are told by the state that there was a series of consultations held over a long period of time, several months, where multiple stakeholders were consulted on this process before inking any document. Do you disagree with this position?
Not only me, because if you maybe you have noticed that almost all the associations said that some of them said that they were not consulted, and some meetings were there with some associations just to show the state of the things going on and not about the consultation. And as I know, almost all the professional associations now had shown their concerns and explained that their consultations, either their consultations are not there or they were not consulted. So that means that this is a big lie made by the minister, or this is a big lie which was said to the minister by his card. Anyhow, now this, if this was a consideration when this was considered in the cabinet, is it correct? Because there's a big lie behind this. More than 50 associations have said that we are against this FTA.
Right, thank you very much for your opening remarks, Mr. Kapila Pereira, Secretary of the Professionals National Front. Now, we did invite the chief negotiator on behalf of the government, Mr. K.J. Veerasinghe, to be on this program to defend the government's position, to set out the government's position. However, he was unreachable. We were subsequently told today that Mr. Veerasinghe is unwell. We were told so by a third party working for the ministry. Now, I have with me a press release issued by the ministry which says here, this ministry wishes to refer to the recent news item where it has been stated that the recently signed free trade agreement with Singapore was entered into without a proper consultation process. The government has adopted a policy of engaging in a dialogue and consultation with all stakeholders in pursuing this goal. This is a press release that we received today. Now, I move my attention now to Mr. D.H. Wijewardena, who is the president of the Sri Lanka Institute of Architects. Now, we are told that this free trade agreement focuses on trade-in services, e-commerce, telecommunications, investments, intellectual property, government procurement. How is this negatively impacting Sri Lanka, in your opinion?
Yes, Sri Lanka Institute of Architects, going to what we said earlier, we actually participated some of the discussions.
Right.
And we clearly said that before signing any FTAs, there are certain things that has to be done as a country and also as a professional institutes That is very important before we go into any sort of agreements. Because if you look at our systems here, they are very big. If you see our immigration laws, if you see our registration of practices, professionals, and if you see the human capital requirement, all those are very, very unclear. And we told the minister very clearly, we are not against the government's policies, because that's a duly elected government. We are always for that. But what we say is that before we sign all these agreements, we have to put our system in order. So that was the agreement, and he agreed at that particular time that this will be, they will keep up to that this promise. But then when you see, they say that we were consulted. True, we were consulted, but we were never shown this document. You know, in the GATS agreement is a very professional, it's an agreement with a lot of rules and regulations, and those have to be filled properly. And we didn't see any of these things at that time, and we said, we very genuinely said, show us, we will contribute to that. So actually what happened was, halfway they did implement certain things halfway. For example, some of the institutions problems were they tried to solve, and some of the institutional problem of our institute also they tried to solve, but they are all sort of half-hearted. But when you go into agreements, that should be the case. Now if you see what they have opened up and what will happen to our profession, and to government to negotiate on profession of architecture, there must be somebody representing the profession before they agree on certain things. But we were not consulted. How can a government agree on a profession that they don't know? This is the issue. So they should have consulted us. Then we will say the situation in this country with respect to architects. So those things should be considered before they go and sign agreements. So they have opened up certain sections, not all. The mode 1 and mode 2 they have opened up. Now mode 1 serves a person here serving architecture services to Singapore. Now how many practices in Sri Lanka has authentic software? Whereas how can we offer services under such circumstances? Are we rich to buy the software? No. But you look at Singapore, it's the other way. So we are not on same line, not on same field. So this is what we are saying. They should have consulted us before all these things are agreed upon. So
you're saying, Mr. Wijewardena, that although consultations were had with you, with your institution, these consultations weren't genuine or meaningful? Is that what you're saying?
No.
Or that your input was not taken into consideration?
No. The thing is, the agreement is one thing. What we discussed was something else. No. Now we said, before signing agreements, they had to fulfill certain requirements. Because we are not ready. Now look at Singapore, a technically advanced country. If you look at Singapore and Sri Lanka at two different levels, what we said, we are not against signing anything, but provided you get things properly arranged. We have to have certain systems here. Whereas now if you look at the explanatory notes of this agreement, the Singapore side and Sri Lanka side, Singapore has very well laid down what they want. I have with me document. Singapore side is full of requirements they want. Our side is totally blank. That is because we were not ready. We don't know what to write. That is the issue, because these agreements are catered to different governments so that all aspects of the governments are covered. But here we have signed some agreement where one side is full of rules and regulations and so on, the other side is almost blank.
Right. Thank you very much, Mr. Wijewardena, President of the Sri Lanka Institute of Architects. My next question is to Mr. Sunil Aberatna, Attorney at Law. Mr. Aberatna, the Bar Association of Sri Lanka has filed a petition against this agreement in question. Could you outline for our viewers what exactly it is that you are in contention with?
Yes, starting from SEPA, then ETCA, the Bar Association with the representation.
Sure.
As distinguished other two speakers explained, time to time we explained the difficulties when we go for these bi-party or tri-party agreements, what are the difficulties or the professionals in this country would face. And we made all these proposals. And our position was, when we go for any agreement, we must have the fair deal with our counterpart. When we don't have that fair deal, then we can't consider that it's a fair contract.
So are you saying that this is unfair to Sri Lanka?
Unfair in the sense, Sonali, now because people might think that we are selfish. No, we are not selfish. All professions must expose to the rest of the world, there is no doubt. But there is a way to do it. Way to do it in the sense, if our professionals, when they are we can't put them into trouble, and then we can't say that we are going to give exposure to the rest of the world. So that first of all we must identify. So what are the barriers our professionals have from our end, and what are the technical expertise we need that we have to hire from outside. Of course, take example the legal profession. Now the technology is developing, construction industry is developing. There is no doubt, because we have to get some experience from outside. It doesn't mean that we have to hire all the professionals and they are that supporting staff also that come to this country. Now, if we really want to upgrade the knowledge and the quality of professionals in this country, there are ways and means. The exchange program is good, but what is the guarantee the government give after signing this agreement that real professionals are coming to this country? What is the level of their professionalism? How are we going to screen them? Do we have any system to screen them considering their educational qualification and experience? Without introducing that, but it is not advisable to go for this type of agreement. Now take one example. In Singapore, you can't just take the engineering profession and various other professions. If a Sri Lankan or Indians or any other citizen from other country, they can't just go there and start their practice, or they can't just go there continue their professional services. First, that they must accept the education qualifications of the person who go there. So then only that they will consider. Otherwise, they don't give that visa for that. They don't give employment visa. They will give only the tourist visa. After a very short period, they have to, even if they are managing director from outside or even the director from outside, it doesn't matter. They will issue only tourist visa. So likewise, that first we must put our end into order.
So Mr. Abhiratna, was not the Bar Association of Sri Lanka engaged in consultations before the signing of the agreement?
Yes, we were in consultation, because I headed the committee of EDCA till March 2017. The time to time that we had number of the consultations, we had number of discussions with the officials. When we gave our recommendations, ultimately we prepared the final report also and presented to the Bar Association on. So the problem is, I don't know that how far they have considered our proposals. My that personal feeling is that the authorities, they have not considered our proposals, and they went ahead to signing this agreement on their own.
Thank you very much, Mr. Abhiratna. I move my attention to Dr. Ananda Ranasinghe. He is a past president and council, Institute of Engineers of Sri Lanka. Dr. Ranasinghe, how are you impacted? How is your institute impacted? How is your profession impacted by the signing of the FTA between the two governments of Sri Lanka and Singapore? Why is it not that a free trade agreement is now looked at as something positive, which sort of opens up the market, makes the market look good globally? Sri Lankans and Singaporeans can sort of work together. Why is that not the way we are tending to look at this?
In fact, actually, as the other gentleman said, architect D.H. Vijayawardena, initially we participated on several discussions on good faith, but still then actually I don't think the government has took our input in order for preparation of these agreements. So therefore we are very concerned. I would like to discuss about a specific issue on this matter, especially this chapter 7 which deals with services. Now chapter 7, we have our own chapter 7 which is 7A, and Singapore has their own chapter 7B. Now in order to come to an introduction of chapter 7, there is something called explanatory notes. Now explanatory notes in Singapore side, actually there are about 6 explanatory notes given in advance of the chapter. And Sri Lankan side there are only 2 explanatory notes.
Right.
Now I will read one explanatory note in order for you to understand the differences. Now Singapore says under third explanatory notes, it says, notwithstanding Article 7.3, that is market taxes. Market taxes is one of the 3 pillars in the free trade agreements. The first pillar is national treatment. That means when we sign an agreement, all nationals should be treated on equal manner. The second one is MFN, most favored nation status. That is, in any multilateral agreements, all nations should be treated in an equal manner. Now the third step is market taxes. Now what it says is actually, notwithstanding Article 7.3 market taxes, non-discriminatory requirements as regard to the types of legal form of an establishment do not need to be specified. So which means actually, although they don't put restrictions on market taxes in the standard form, it is not applicable. That means actually they can have market access restrictions indefinitely. Now our parallel column says nothing in respect of market taxes. We have not qualified anything. Now item number 4, this is regarding the qualifications of Singaporeans. They say, I will read a little, actually it takes a little bit of time. The schedule does not include measures relating to qualification requirements and procedures, technical standards and licenses requirements when they do not constitute market taxes or national treatment. Limitation within the meaning of Article 7.3 and Article 7.2 national treatment. Those measures need not be, example, need to obtain licenses, universal services, obligations, needs to obtain recognition. So there is a whole list that, supposing if a Sri Lankan engineer or an architect wants to go and work in Singapore, he has to undergo all these lists which is given here. Whereas our list says an expert can work here, an expert who is coming from Singapore. Now the definition of expert is very loose. Now it says specialist. Specialist is loosely very defined. So therefore I don't think we have put consideration in preparation in these agreements. That is the most dangerous things. Not that we are against investment in this country, but the thing is actually the agreement is basically one-sided. The whole reason is actually professionals were not invited, especially lawyers, I don't know, not invited to go through this agreement and see the pros and cons of this agreement, because we have left blank on the other side, whereas Singapore, they have perfectly qualified themselves. Not a single person can go and work there, as attorney at law Abhiratna said, because they say that you even have to sit for exams in order to practice there. So that is how it has been worded. So therefore we are completely lost at this agreement, because I don't think proper consultations has been done. Had it been done, it wouldn't have been like this, what has already been prepared and signed.
Thank you very much for that very specific example, Dr. Ananda Ranasinghe from the Institute of Engineers, Sri Lanka. Finally, I move my attention to Kitmina Hevage, who's a research officer at the Institute of Policy Studies. Kitmina, a lot of criticism against the FTA with Singapore. Perhaps you'd have a differing opinion. What are your thoughts on this? Do you think that proper consultations were not done, or substantially is the document at fault? Where do you where are your thoughts with regard to this enterprise?
So I think, Sonali, since I'm not a government representative, so I don't want to comment on the the negotiating process or the consultation process per se. But as my colleagues have already noted, there has been some form of consultation. It seems to be the nuances of what was included in the treaty and what was not that seems to be contested here. But I think what's important is to draw attention to, I guess, some sort of misunderstanding of facts, if I may say so myself. For example, there has been some concern that anyone with a work permit in Singapore or anyone who has access or permanent resident in Singapore can just walk into Sri Lanka and start working here. That is mode 4 liberalization, and that is not liberalized under this free trade agreement. What is allowed is that we allow intra-corporate transfers, and even in that there are certain specifications in terms of what constitutes an intra-corporate transfer. So it means that anyone who comes a Singaporean national or a permanent resident who has to have had worked at the registered Singaporean company that has invested in Sri Lanka already for at least 1 year. They have to have 5 years work experience, and they also have to go through certain qualifications or regulations that are set by the industry standards in Sri Lanka.
So it is qualified? It
is qualified. So I think that's very important, because it's not a kind of a free pass for all Singaporean nationals or permanent residents to just come into Sri Lanka. There are qualifications as to what constitutes that to allow someone to come into the country. And also I think it's important to note that it's only intra-corporate transfer. So it's only a Singaporean company that invests in Sri Lanka, and then an employee of that company can come into Sri Lanka. And even then, there are 3 stages of which are allowed. So managers, executives, and specialists. And those are laid out in the agreement specifically as well. So I think overall, there seems to be some misunderstanding of what is included and what is not. In terms of the consultative process, and I think that's a major form of contention here, is yes, I think there is a lot of room for improvement in terms of what the government can do, in terms of how they consult professional organizations like my colleagues here, or even the public in general, speaking to the public as to why this agreement was brought forward, because some of the main beneficiaries of free trade agreements like this are not individuals like us, it's the consumers. Because they are the ones who will gain through the investments, and they are the ones who will gain through the tariff reductions on imports to Sri Lanka and so on.
Fantastic. Thank you very much, Kit Minahevage, Research Officer at the Institute of Policy Studies. That concludes the first round with the opening remarks from the panelists. Before opening the floor for questions from our 2 journalists, gentlemen, it is of paramount importance that there is no misinformation or disinformation that sort of makes its way to the general public. Ms. Abhiratna, how should the government have better handled this situation? Because a free trade agreement is not just a contract you sign over the counter. It has a lot of consultation with multiple stakeholders, months and months of poring over the nitty-gritties and analyzing all the sort of impacts of it. Although the state has consulted various professional bodies, we now have this free trade agreement, the topic of conversation once again. What have we done wrong?
Sonali, now take one example. One area of this agreement is dispute resolution. Now, when you take dispute resolution, now what is the role of attorney at law here? It's specified under Judicature Act. They can give the consultation, that they can appear the judicial bodies, and they can appear before courts. Anyway, that foreign lawyer or any consultant, they can't appear before our courts without getting permission of Supreme Court. They have to take oaths. So that is out. Anyway, they can engage in the consultation. So they can give advice. Now, problem is, now we must not forget the fact that there may be some instances under professional negligence. When there is professional negligence, how are we going to deal with that issue? Of course, bar association is also that engage in to improve the quality of the citizen in this country. Being professionals in the legal profession, that is one of our area, one of our objectives is to protect human rights and fundamental rights and improve the quality of the people. In that, of course, that as I explained you earlier, that we are not a selfish organization, we are not a selfish professional body. We must have that mixed with other professionals, that is true. But there must be a screening process. Screening process in the sense that in these agreements, there must be some basic or that minimum requirement specified to come and that give the legal opinion or whatever it is in this country. Now take example, it is not a difficult task. This is what we proposed. That after consulting the University Grant Commission, and they can get information. What are the accepted universities in the world? Not only without limiting Singapore, Sonali, we will discuss about that. Anyway, in future there will be more and more trade agreements. So then we know what are the accepted and qualified universities who that produce the real graduates relevant to the legal profession. So then when a graduate or professional come from, so this type of the universities, we know that he is coming with some that knowledge we can accept. And what is the mechanism when there is a professional negligence taken place? How we are going to deal with that issue? Now, especially that we
Mr.
are
Abhiratna, what's the current mechanism in Sri Lanka to deal with professional negligence?
Yes,
professional
negligence. The professional negligence that anyone can directly report to Supreme Court. Sometimes Supreme Court refer these matters to Bar Association of Sri Lanka. The role of the Bar Association is to conduct, if there is any misconduct, that we have professional purposes committee, that we have to take disciplinary action after hearing both parties. And this is also recognized under Adjudication Act.
Now, on your, you mentioned about how the skills, etc., have to be clearly defined. In the statement that was issued by the Ministry of Development Strategies and International Trade, they say only the most skilled and highest tiered personnel are eligible. This is clearly defined in the schedules of the agreement. If a person has a dominant and effective nationality within quote marks in a third country, such persons would be excluded. Are you saying that this has not been, that this is not the case? Because in that case, that would mean that the ministry is lying.
Yes,
in this
they
statement.
can do it after consultation with the Bar Association of Sri Lanka, because this is the official body for the legal profession. So with the consultation or with the, you don't even.
No, my question, Mr. Abhiratna, is that the ministry in its statement is saying, I'll read that complete part to you. The only permitted entrants are those who qualify as corporate transferees, persons employed by a Singaporean company with investments in Sri Lanka. Third, such persons would have to be employed in that company for at least 12 months before coming here. Furthermore, only the most skilled and highest tiered personnel are eligible. This is clearly defined in the schedules. Has it not been clearly defined in the schedules? My question to you then is the ministry lying in the statement?
The ministry, that may be the objective and that may be the idea having. But anyway, that up to the signing of this agreement, have they given any guidelines to find out their qualifications? What are the qualifications they are defined, especially relevant to legal profession?
Just one final question for you, Mr. Abhiratna. This is on a matter of law. Is this agreement is currently not in force, is it?
Because our views, that is why we have filed that fundamental rights application, because I don't like to go deep into that, because it will be sub judice. Now it will be pending.
Okay, let me ask you, I'll not ask directly regarding your petition, but when Sri Lanka signs a free trade agreement or a treaty with another country, my understanding of it is that, for example, with treaties, if you take the ICCPR convention, we had to pass enabling legislation in Parliament, and even though it was signed by the government of the day, it later had to be ratified by Parliament. Is this the case for all international treaties and agreements, including free trade agreements, or are FTAs sort of separate to that?
No, this agreement also comes under the Article 157 of the Constitution.
So it has to be ratified by Parliament for it to come into effect.
That is fine.
Thank you, Mr. Aberatne. Mr. Wijewardhan, I'd like to come to you. You were talking about the technological advancements of Singapore as compared to Sri Lanka. Don't you feel that Singapore has been able to become so technologically advanced because of the technological knowledge transfer that has happened through trade? And aren't we losing out on that by closing Sri Lanka to trade?
No, to answer your question, I must draw your attention to these GATS agreements. So they are part of WTO. So if you when we sign an agreement with another country, we have to follow the GATS agreement. I told you the GATS agreements are very professional, very detailed out, so that no injustice happen to any of the countries. So you have, if you look at the explanatory notes, you have the modes of supply, horizontal commitments, vertical commitments, market access, limitation, additional commitments, and most preferred nations, MFN. So these tools are there for you to control certain things. That's why we told the government, first we say, who are the people we need this country? What is our legal requirement for getting visas? You know, what sort of, those things must be in place. So these, I told you, these tools are there. Say supposing now, say for example, if you don't have naval architects in Sri Lanka, this agreement provides you can limit those things when you use these tools, right? But that is where the professional input should come. Now without studying, because these agreements are very fair, but provided, that is why we had to negotiate. During negotiation with the government, now we see the Singaporean side, they have studied very well. You know what they want from Sri Lanka, what are their expectations, very good. But from our side, what was our expectations? How do we protect our professionals?
Kitmewan, this contention has been raised by almost all four of your fellow panelists today, is that whereas Singapore has been very clear and articulate in what it is that they expect from this trade agreement with Sri Lanka, this is not the case with Sri Lanka. As a research officer at IPS, having studied this agreement, what do you have to say about that?
I have to respectfully disagree with them. In the sense that I think it was clear as to what the objective of the treaty was, of the agreement was, is to attract investment. So this is not a free trade agreement that was trying to get market access in terms of goods trade to Singapore.
But it does raise on tariff lines, it talks about removing up to 80%.
Absolutely. The priority is not goods trade. The priority is in terms of service liberalization and investment attraction. Because Singapore is a well-known hub for services, and also a good and strong treaty with Singapore sends a strong signal to the rest of the world, particularly the ASEAN region, because at the end of the day I think Sri Lanka is trying to plug into the RCEP, which India and China and Singapore and all these other countries are negotiating. So I think, like I said, the priority was in terms of service liberalization and investment attraction. And in that, I think there is a clear strategy in terms of identifying what service sectors are opened up, because not all service sectors have been opened up under this treaty. It has been clear that there are certain sectors where Singapore is quite good at, and that Sri Lanka has a competitive advantage in attracting those investments. For example, tourism, the hotel industry, for example, broadcasting and telecommunications, where Singapore is already has invested in Sri Lanka, and therefore Sri Lanka can gain more with further investments in that sector as well. And there are other sectors. Sure.
Well, one thing, you mentioned broadcasting and telecommunications. Should I be worried about my job?
I guess we'll have to see.
Kitmira, at the same time, Dr. Ranasinghe raised the question of the explanatory notes. And as he mentioned, I can't see the document from here, but as he mentioned, the Singaporean note went into quite a length of detail, whereas the Sri Lankan note was quite blank. What do you have to say on that?
I think we need to take the agreement as a whole. So even though the explanatory notes might be blank on one column, some of the standards and qualifications, like I mentioned earlier, have been set out in other chapters of the agreement. And also in terms of the broader regulations, in most of these service sectors that have been liberalized, it says that the professional regulations that are set for domestic suppliers, so people who are engaging in that service domestically, will also be set for the Singaporean that is working here. So those regulations are set through the agreement, maybe not necessarily through the explanatory note. However, within the agreement, some of the qualifications are set quite stringently.
Mr. Wijewardena, yeah.
Just one question, one more question. I want to bring Kapila in on this discussion as well. Kapila, for the Professionals National Front, you said that the main issue here is that this opens up services. But the ministry is here saying that, again, as I mentioned before, this is only open to intra-corporate transferees. And Kitmin also laid out the criteria that is in place. Is that not acceptable?
Yeah, that's true. But the thing is, yes, Kitmin said that, Mr. Kitmin said that, yeah, it's for, they need to have a 1 year, they are in this,
in that company.
In that company before coming here. So that is the only thing.
And 5 years experience.
5 years experience.
And they have to be at management level.
Yeah, 5 years experience from an Indian or Chinese. And is there a way to screen that from our side?
Working in a technologically advanced economy like Singapore.
Yeah, that is, we can agree on that 1 year that he was in that company. Okay. But if he is Indian or Chinese, will that be true, the previous experience that he is having? I don't know. You have to look at the world and learn those things.
But so see, my problem is this. Now, Mr. Wijewardena mentioned that Singapore is a very technologically advanced country, and it would be difficult for our professionals for our companies investing in Singapore to take along professionals from here that we are not rich enough to get into that kind of thing. So, given that Singapore is such a since we admit that Singapore is a technologically advanced country, and that Singapore has sort of highly qualified people working there as well, why would a Singaporean company investing in Sri Lanka bring a substandard professional to work for them here? The logic doesn't add up. Don't you think so?
No. The thing is, even if you go to the US Department of Commerce site and exports.gov, if you go there and if you check that one, you will see that the best sector in Sri Lanka would be the IT sector. So in here, through the Singapore agreement also, that they have touched this IT sector and they have opened that one. And that means all these people are looking at this service segment in here, and they want some benefit from there. So we should not think that a Singaporean will not come here, even if it is bit expensive to compete with someone in here. Maybe it is, but still they will provide the jobs to the Indians and Chinese and Bangladeshis and everyone, and they will do that.
Mr. Pereira, you took up issue with something that Kitmina said, so I think we need to give him time to respond. Kitmina, what are your thoughts on this?
Just a clarification about the agreement. It doesn't allow Indians and Chinese and Bangladeshis to just come into Sri Lanka and work.
Sure.
They have to be a resident of, they have to be a permanent resident of Singapore or a citizen. And in case of dual citizenship, there is something called dominant citizenship, and this is a very well established legal principle that I'm sure my legal colleagues will be able to clarify more. But so there are, I mean, it's very restricted to those, to Singaporean nationals and permanent residents, and as was discussed, again there are qualifications in terms of the standard set as well. So I think it's important.
Let me assist you with that. It says here, and I'm reading off the press release issued by the ministry. It says the only permitted entrants are those who qualify as corporate transferees, i.e. persons employed by a Singaporean company with investments in Sri Lanka. Such persons would have to be employed in that company for at least 12 months. Furthermore, only the most skilled and highest tiered personnel are eligible. If a person has a dominant and effective nationality in a third country, such persons would be excluded. So I think that clarifies the position. Charita?
Yeah, Mr. Wijewardena, you mentioned that during consultations that you were promised that this free trade agreement will not be signed until our domestic conditions are put right. So you know at what pace the government moves, right? So how long do you think it will take to put the domestic conditions right? And do you mean to say that the FTA should sit on a shelf somewhere until our conditions are right?
Certainly not, because government can implement, and we actually volunteered. We volunteered to come and work in the ministry, the engineers and also architects and some of the other professionals. We agreed to come and work with the government, because thing is, it's not shelving. Now if you see the Architects Act of Singapore is the strongest act in the world. You can't build even a pump house without architect in Singapore. What is the situation in Sri Lanka today? There are regulations formed by last government where non-professionals can go build up to 3,000 square feet of buildings. So those are the things we said we correct this. So we have to be in par with them. You know, now my good friend said that certain professionals are allowed, the experts and so on and so forth. But they haven't specified who are these experts, what are their background. You know, there's something called the most preferred nation, MFN. That has not been used. That is for, say, in a certain country, certain professionals need certain improvements. You can get time till up to 5 years. You know, so that until such professionals are developed to a certain extent, that can be certain limitation can be done. Now, how can the government go and agree on an architecture profession without a single architect being there at the discussion? What do they know about the architecture practice in this country? You see lot of buildings are coming all over Colombo. Who are the designers? So first we have to set this order. We are not against anybody, any government or any system they want to implement. But we are working with a country where so much of regulations and they are well placed. We can't blame the Singapore government. They have done their duty. It is we. Actually, this is a very intelligent document. What we have done, we should have studied what we want, what we don't want, and where are we weak, and we could have adjusted, because I told you, so many tools are there.
Mr. Wijewardena, now since you comment on the negotiation process itself, what is your take on Sri Lanka's capacity to negotiate tough, conditions like this? Are you satisfied with the negotiating team?
We don't know, because we were promised a seat. Our professionals were promised a seat. Actually, the minister agreed to give a seat. We said we don't need to put anything. Give us a status of observer. So we can observe and see if there's something going wrong, we can tell them. They promised the seat in the negotiation, the discussions. We said we'll come.
This was promised verbally, or was it minuted? No. Was it in writing?
We actually, in the sense that we went for meetings, then meeting minutes were done. So I don't know, I'm not too sure whether it's there, but they agreed to me verbally, to us, all of us, those who were there. They agreed that a seat will be created for us, and in fact we fished out some person so that we will sit off those things. We don't want to comment at that time, but we come home and say these things has to be corrected, but we were not given a chance, and we said we will go on our own, spending our own money to these negotiations, but they didn't allow us. I mean, now people talk about brain drain, right? So now he said that no Singaporean national will come here. Now the thing is, the investment is, all 4 modes are open. So when they come for investment, they will come here, they will look at, okay, they can employ people, Singapore national, they can employ. Now they will look at, okay, it's better to have a Sri Lankan one or better to have a Singaporean one. Now when you go to Sri Lankan, you have to pay EPA, PTA, various laws will come. Now, so therefore, these tools should have used very carefully so that we can really get investment and we can improve our professionals. So that has not been done. That is our case. We are not against this, but this has not been handled properly. That is what we are saying.
Kitmina, if you look at other regional countries now, for example, say Vietnam, free movement of skilled personnel, right, top tier people, have actually been one of the factors that have helped fast economic growth, right? So how have those countries dealt with situations like this when they opened up their economies and signed free trade agreements?
It's a very similar situation in that, because Vietnam is also a small economy like Sri Lanka, and there is a disparity in the size of the economy. So Singapore and Sri Lanka, or Vietnam has a FTA with the USA, for example. And how it happens is similar to that. What they also wanted was US investments in Vietnam, and for that they allowed US investments, and along with that certain professional management level professionals to come in and, for example, manage or be executives or so on, that will help that. So in terms of the labor, it comes from Vietnam, but the management level and higher ups can come from the USA and so on. I think it's also important, and something that we don't seem to be talking much, is the demand side of things. The fact of the matter is, we are talking a lot about who's employed as an IT professional and so on, but the fact is the IT industry has wanted Sri Lanka to liberalize its industry, has wanted labor coming in from other countries, because there is a dearth of labor in the industry. So there's a demand for this liberalization as well. So I think that needs to be kind of taken into focus and be mentioned in that sense.
Dr. Ramasinghe, I want to talk to you of all of the cons that have been highlighted with this agreement. One that initially stuck out to me was, how will this impact architectural and engineering services? Now, in response to that, the ministry has said that it does not, the concerns that engineering and architectural services have been opened is incorrect. The ministry wishes to state that the only commitment is for cross-border services via the internet and not relating to movement of people, and that too limited only to pre-design advisory and consultative services, and does not include the practice of architectural or engineering professions.
Now,
is that incorrect, or will we be seeing a free movement?
In fact, when we went and met the minister after signing this agreement, one of the officers said, "Why are you worrying? Because this cross-border supply is already happening in this country. So why, when it is put to agreement, why are you concerned about this one?" That is the most dangerous thing which has been included in the agreement, because cross-border means there need not be physical presence. Now in Sri Lanka, let's say if somebody wants to design a 40 or 50-story building, you don't have to have anybody here. The entire design can be done from Singapore, and drawings can be done from Singapore and just transfer here. So how many people in Sri Lanka will lose business, or architects, engineers, etc., because we will not be considered, because although we have the capacity, probably we may not have the capacity to do it in quick time or whatever it is, because we as architect Vijayavardhana said, we might have to buy expensive software for all these things. So therefore it is extremely dangerous thing probably. Now if the government wants to put a stop at one stage, Once we sign an international agreement, you can't do that because you have to pay large sums of compensation. So therefore, I think the officers probably they don't know what's happening really, because cross-border supply means actually you don't have to have a single person here, but you can get the services from Singapore. So it will shut down completely of some of the industries. Even it could be affect even small-scale industries.
But Dr. Anasinger, the ministry also says in its statement that cross-border services, and that too limited only to pre-design advisory and consultative services.
Now that is also a wrong statement, because the thing is actually probably architect Vijayavardhana might agree. Now the thing is actually when you prepare a sketch drawing, preliminary stage, and supposing if that information is given to a Sri Lankan, nobody can develop that design because there is a copyright involved in that matter. So therefore it does not mean that once the sketches or skeletons are done, it can be transferred to a Sri Lankan company and develop it. So you might have to pay large sums of copyrights. So therefore, although it has been stated, as you said in the term pre-design advice, nobody can grab the job from there and pass it to a Sri Lankan company, because there is a lot of copyright involved, because we have party to the TRIPS agreement. Probably Attorney at Law Abhiratna will tell, we are party to the TRIPS agreement, so we will be violating copyright laws.
Right, thank you very much. Nadeem, I'm afraid we have to go in for a short commercial break. We're talking about the impact of the free trade agreement between Sri Lanka and Singapore. What really is this document, and should the Sri Lankan public be worried? All these misconceptions dispelled on this edition of Face the Nation. Stay with us, we'll be right back. Welcome back. This is Face the Nation. We're in discussion with an eminent panel of guests. What really does the FTA between Singapore and Sri Lanka hold for us Sri Lankans? That's the topic of a discussion today. I start off first with Mr. Sunil Abhiratna, Attorney at Law, representing the Bar Association of Sri Lanka. Mr. Abhiratna, one of the preconditions of entering into this free trade agreement was to ensure that Sri Lanka has the necessary anti-dumping legislation in place. Could you outline for us the fears that certain parties have that Sri Lanka would be the dumping grounds for low quality goods, services? Some of the fears that are surrounding this agreement are that Sri Lanka needs to be cautious of not becoming a dumping ground of imports coming from third-party countries attempting to evade tariffs through Singapore. So this is one of the misconceptions that seem to be floating around. What are your thoughts on this?
No, actually, this is what that we are asking the authorities. Actually, that when you look at this agreement, there are some provisions, of course, that these areas are not covered properly. Now, take examples of the service sector, especially the legal provision, as I explained you earlier. That our worries, because we also like to share our views and ideas with that foreign lawyers and expertise in other countries. Now, the question arises whether how to trust their quality and how to trust their opinion, legal opinion given by them. If something goes wrong, what is the mechanism? So likewise, even it applies to the goods and services both parties, because we are entering into gets and gets. Of course, there is no doubt about that. Sri Lanka is one of the members of that. So then we have to, not only recently, that we have the long history, that we are following this WTO, their agreements, and we are part of their WTO. Now the question is, as you explained, that signing this bi-party agreement with Singapore, sometimes that fear is there, because goods or low quality goods or services can come through Singapore. Now this is our worry.
However, Ms. Abhiratna, the legislation was brought in, it was enacted.
Yeah.
So then there is no issue there.
No, but that legislation in the sense now, that is why what is the screening method? Screening system is not there.
So shouldn't the mechanisms then, since the legislation was only passed recently, I think in March if I'm not mistaken, shouldn't the regulations then be streamlined gradually?
Yes, actually.
Don't you think that you are taking a far more pessimistic look at this situation than what it already exists as?
No, what we say is, because actually that is good that the government is developing, because there is no doubt about that. Now, only thing is, before we sign the agreement, because they must satisfy the professionals who are in this country, because there is nothing to hide. Because even before signing this agreement, of course, as my other colleagues said, of course, actually that we were under the impression that the authorities will give us a fair opportunity to make our contribution. So if that is the case, of course, that we could have given our input to that.
But you were consulted, right?
Yes, consulted. Now that we went for a round of discussions, that's it. We were not consulted.
Your input was not considered?
No.
As the Bar Association of Sri Lanka?
No,
you didn't study the documentation?
Because we time to time we went and explained. We asked for even for this agreement, or for a number of occasions we asked the exact agreement. We didn't get it. Through another organization only that ultimately we found this, and we went through this, and as a result the Executive Committee of Bar Association finally decided to file this fundamental rights application.
Right. Okay. Thank you very much, Mr. Sunil Aberatna, for your input and your thoughts. I'd like to move my attention to Mr. Kapila Pereira, Secretary of the Professionals National Front. Now that the agreement is inked, how do you suppose we need to move forward as a country, as professionals? We need to now work within this framework, and how do you propose we need to do that?
You mean with this liberalization, how to move forward?
Yes.
Yeah. First thing is that we know that several parties has go for the FR petitions. So we need to go through that process.
Right. Okay.
And see what's going on there and what is the result of that one.
Okay.
And then one problem here is that our government believes that the answer for all the issues is to liberalize the service sectors and everything. Yeah, in a way the liberalization could be good for some sectors, as this panel already explained, and they have already explained that we should have used the tools there in the commitments, horizontal and vertical commitments and other things. We should have considered them and we should have placed them correctly. We didn't do that. But the thing is that why our government is always thinking that liberalization is the solution for all these issues in here, for the services and everything. For example, that as Mr. Kitmina said, that okay, at the moment we don't have any issue in, if I take the IT sector only, we don't have any issue in the number of employees here. Then they started to discuss about the ETCA agreement or SIPA from the beginning of this government and maybe somewhere during the previous government. But what they did to improve the number of graduates, IT graduates coming from the private sector and government sector, from the universities. If they did that, if they feel that we need more employees here, more graduates, they could have done that, because now it's more than 3 years. If they started to do that, now we already have employees. You see the point, because they are not honest. They are doing something else. That is the thing.
So Mr. Pereira, what you're saying basically is that the government initially needs to take steps to put the house in order first before venturing into free trade agreements. Is that what you're saying?
Yeah, when we are thinking about the free trade agreements, yes, we need a national policy and a protocol to see whether these things are going under the good governance procedures, because we don't have any procedure. If we take the this central bank scandal, there is a protocol. So that's why we can say there's something wrong there. But in here we can't say and we can't prove there is something wrong here, because we don't have a protocol, right? That is one issue. So we don't have a national policy, we don't have a regulatory framework, and as to the WTO, we can't bring in more laws and regulations after signing an agreement as well. There are some commitments there, isn't it? So for the service sector liberalization, this issue is there. But why we are liberalizing? In a way that we are liberalizing to get the if we are liberalizing to get more employees, and instead of having some from here, why we haven't tried to give those jobs to the Sri Lankans instead of giving it to some other country, because they were looking towards India as well, and still they are looking at that, and they will start next negotiations with India soon at the end of May. So this is in the pipeline, so we have to be a bit careful, because now India will bring the pressure to Sri Lanka, because now they have liberalized service sector with Singapore, and they will bring the pressure that saying that okay, do that for us as well. And from the beginning that I am saying our government is not ready and not skilled enough, because on the same day that the Singapore agreement was signed, they released a press release. Singapore, not Sri Lanka. Ministry of Trade and Industry, Singapore. And they really know what are the benefits here. And they are saying that Singapore exports will enjoy potential tariff savings of about $10 million each year. And they have some more benefits. And at the end they are saying greater protection of investment, and they are talking about the arbitration, and this is aligned with the objective of promoting Singapore as an arbitration hub. So that means they are ready to go for arbitration at the beginning. Right?
Mr. Pereira, anyway, when it comes to arbitration, Singapore is an arbitration hub.
Yeah, so they are promoting that through this agreement as well. So one benefit, they are
Mr.
clearly
Pereira,
stating that.
I don't see anything wrong with that statement.
No, it's not wrong. I'm not saying. I'm saying that they are very ready with this stuff, and our government only issue a press release when we force them to do. So when we are continuously confronting them, then only they are giving these details and explaining the stuff.
So you're saying there needed to be prior consultation, not post consultation.
Consultation. The thing is that it's not about the consultation, because they don't consider that one. That's what I feel.
Right.
They just act and just show a consultation, because everyone in here says that their consultation was not considered, because maybe they have neglect architects, but they should have considered engineers, they should have considered lawyers. So maybe.
Right. Thank you very much, Mr. Kapila Pereira, for your thoughts and your observations. Mr. D.H. Vijayawardena, you're the president of the Sri Lanka Institute of Architects. Could you tell us if you are in principle against free trade agreements as an institution, or is it only the issues in this particular agreement that you are sort of holding contention to?
I think I told very clearly, we are not against government policies. If the government think investments can come to trade agreements, yes. But you have to see, it should benefit the people of this country, the professionals of this country. That should be the motive. Now if you see, now they have, I told you, now how can a government official go to Singapore or somewhere and talk on behalf of architectural professions of Sri Lanka without talking to us? Now we have to see what is the status quo of this country, what has happened to Sri Lanka when it comes to architectural practice. See now the things like, I must say that we built airports, we built our second airport. Does it look Sri Lankan? No. We built certain stadiums, our national theatre. Our national theatre is built by foreigners. We have 2,600 years of history. I went to a certain place where they displayed the cultural buildings of various countries. And in Sri Lanka, you have this building designed by someone else. So that is the status quo of this country when it's going to architecture. So we had to correct those things. We say brain drain. So we have to see that, you know, our professionals are at certain level. Now my good friend said that nothing will happen. The mode 1 is open, mode 2 is open. But when you open the mode 1, now he asked the question, the sketchers, the first schematic design comes from Singapore. Who is going to develop that here without paying his price? And what is his price? Then what is now? On the similar way, we design something in Singapore. You know, when this software came into the picture, Singapore government supported the professionals and developed their own software. So all the Singaporeans use authorized software. That is how the government protects the profession.
But right, so are you saying that the Sri Lankan government is not protecting its professionals? Is that
certainly what you're saying? Certainly not.
Right.
We have to protect the system. That's what I told you. We have to see the situation in this country when it comes to, I am the president of the institute, what is the status quo of architecture? So what are their problems? When you open up Singapore, what do you want? We said our act should be changed. So they went on doing that, but it is now halfway. And we say our professional act should be protected. You know, there are certain regulations where non-professional can practice and design buildings up to 4,000 square feet. We said we want to change that. Now, without changing that, what is the purpose in going and opening these things? Now,
Mr. Vijayawardena, now that the agreement has been inked, what steps does, in your opinion, does the government need to mandatorily take in order to protect the architects of Sri Lanka?
You know, when two sovereign nations sign agreements, we feel we are really stuck. You know, now these GATS agreements, once you sign one agreement, we have very big impact on the next agreement. What we agree with Singapore, we can't say no to India,
that's
no
right,
to
but
China.
Protection mechanisms within the country, within the national framework can be strengthened. So what is it that you are telling the government? Because I'm quite certain that there are government representatives
Number one, we are asking,
tonight.
stop signing agreements with China and whatever the countries. They say, at least now, talk to us, look at our problems, right? And then to see. Now, I think this will be revived in, there's no point going and protesting because two sovereign nations have signed. So, I think what we have to see, at least at what point this can be revived, because we cannot revive with the consent of the other country, because it's a sovereign nation. So we have to see at least this point. That's why we actually, professionals got together and asked, take it to the parliament and debate. So then only these things will come out. We are now only we are seeing certain things in this agreement. You know, I think that should be the case, because if you go and sign these agreements without looking, now say Singapore additional commitments with respect to any measures in mode 1, 2 or 3 covered by CPC 8671, that is architecture, shall accord immediately, unconditionally to service supplies of Singapore treatment no less favourable than that it accords to like services and service suppliers of any other party. Suppose if you go and sign an agreement with India, and if we give something more than what is stated here, this additional commitments only Singapore has requested. We have not requested. Singapore has requested. We have to give that same status to India and Singapore. So what I am saying is, these are very good format. Good format for GATS. It has given all the measures to cover yourself, protect, and then go get the investment. But we are saying that has not been followed. This good agreement, this side is full, this side is blank. So that is the issue.
Right. Thank you very much, Mr. Vijayawardena. I move my attention to Engineer Dr. Anand Ranasinghe, past President and Council, Institute of Engineers of Sri Lanka. As an individual who is representing the engineers, who are a major stakeholder of this free trade agreement entered into between Sri Lanka and Singapore, what specific grievances do you now have that you think the government has a responsibility to rectify?
I want to say, actually, although as a professional organization we are participating, we don't say that we are concerned only about engineers. This is a concern about the general public. Now what I want to say is, actually, when you sign agreements, we have to have the very smartest people when signing agreements, because there are certain things that we have to look into. Now for example, I will tell what we have done wrong previously. Now we have signed a hedging agreement, what is called for oil hedging. Now the main mistake which we have done is, actually, there was a cap at the top saying that if the oil barrel is more than $200, the Deutsche Bank or the other three banks there, they will pay us the excess. But if you are below the certain amount, the Sri Lankan government had to pay to the banks. But unfortunately, the total figure, total compensation, there was a cap. There was no cap. There was cap at the top level, and there was no cap at the bottom level. That means if the oil hedging prices went down below $100, I can't remember the exact figure, $100, we had to pay indefinite quantity of money to the Deutsche Bank. So therefore, people have to be very smart when you are preparing agreements. Now you were talking about international arbitration at Singapore. The cost of arbitration alone, only for Deutsche Bank, we had to pay 1.2 billion rupees. So all these are coming with a price. Don't think that Singapore is the smartest country or technologically advanced country so that we can be probably reach that stage. But we have lot to lose, actually, if we are not smart. Now these international agreements, I would say, mostly these disputes are resolved by arbitration. So there are countries actually who has gone bankrupt by paying arbitration fees. There is a famous case, let me say, give me about few minutes. Now there is a case called, I have. This is Philip Morris versus Uruguay. What happened was, actually, in that case, the Uruguay government wants to introduce, I would say, some packet advertisement saying that smoking is dangerous for your health. We also did it some time back. But in order to do that, the Philip Morris company claimed US dollars 2.2 billion compensation, because what they say is, when we are investing money in a country, we are anticipating profits for so many years, 30 years or 40 years. So you have to pay compensated for all 40 years. Now we have serious problems with environmental issues. You know, very recently aerated bottle company discharged polluted water to the Kalin River. Now what is the remedial measure we have done? So therefore we don't have systems in operation. But Singapore, you can't do a simple, you can't even open your shutter and speak to the road. So they are being supervised. So we have nothing, we have no systems, we have no supervisions, our environmental is polluting every day. Today news is that for last 4 months, 90 elephants have died due to various incidents. So we have to protect ourselves. It's not only investment, we have to protect as a country. So it's very unfortunate that people, those who are not in various contribution of other professionals have not been considered in these negotiations. Although they say we have been consulted, what we got when we had the discussion with the minister was, now it is too late. That is the last discussion. But minister, you can give your input when we are signing the other agreements. That was a remark made by the minister when we had this discussion.
Right. Thank you very much, Dr. Ananda Ranasinghe, past President and Council, Institute of Engineers, Sri Lanka. Finally, Kitmina Hevage, Research Officer of the Institute of Policy Studies. Now, Dr. Ranasinghe has said that we don't have systems and supervision mechanisms in place in Sri Lanka. And Kitmina, frankly, listening to this conversation, we all get the idea that Sri Lanka first needs to put its own house in order. In the light of this conversation, what are your thoughts?
I agree that there's a lot to be done domestically in terms of reforms, and one of the fastest ways of getting reforms done is unilaterally. However, we see movement towards those reforms. For example, you mentioned the anti-dumping law being introduced about a month or so ago. There are reports that the immigration law is going to be reformed this week. It's going to be brought in front of the cabinet. So some of the concerns that were brought up are already addressed through that. And yes, there are reforms that need to happen in terms of regulations and so on, but there's a move towards that. There's a second option, and I feel like that is something that is being adhered to here through the agreement, which is that we have set the reforms, now it's through the agreement, and it's now a matter of implementation. Because I think for long, Sri Lankan industries, both in terms of manufacturing as well as services, have gathered a lot of protectionism in terms of different government policies, and our overall competitiveness has lowered splendidly over the past few years. In fact, Sri Lanka is one of the has dropped down in terms of the global competitiveness rankings because we have been so uncompetitive, our cost of production is high and so on. Whereas small economies like Vietnam, the Bangladeshis and so on have improved because they have liberalized either through agreements or unilaterally. I think it's time that we recognize this, and unfortunately due to this protectionism, we have situations such as pirated software being used. Right? So just because we've been engaging in bad practice doesn't mean that we should continue those bad practices. I think we need to make a call on whether we need to introduce good standards of practice, and in terms of introducing competitiveness through our industries. And I think that's what this agreement does, is in bringing foreign Singaporean investment into the country to improve our competitiveness. And yes, there are going to be winners and losers as in any trade agreement. And I think that needs to be communicated well. That this is not a very flowery agreement that everyone is going to kind of win. There are going to be winners and losers. But when you look at this agreement on net, it's a net positive agreement because it sends a signal to Singapore and it creates the regulatory framework for Singaporean investments and even the services that are being liberalized. For example, an investor who comes to Sri Lanka will want some sort of architectural advice or legal advice, pre-design advice from a Singaporean client that they have back home, right? So they are not going to want to just come to Sri Lanka without any of that backup support. So that's what this agreement does. Even when it comes to liberalizing certain services, they've been liberalized so that it creates confidence for investors to come to Sri Lanka, and that in turn creates jobs. For example, the IT sector. When Singaporean companies would come to Sri Lanka, that in turn would create more jobs for IT professionals in Sri Lanka and other services as well. So I think overall, yes, there are going to be winners and losers. Yes, there are going to be losers. But given that this is a net positive agreement, I think it's important that we don't misrepresent facts. And also it's important that we communicate the right facts. I think that's where the government maybe should improve in terms of communication, of communicating those facts to the public, because this is an opportunity to become more competitive and to move up the ladder in terms of growth and in terms of plugging in to global trade and investment.
Kitmila, points well noted. However, you can't dispute the statements made by the 4 panelists before you who belong to 4 professional bodies who all said one thing, that they were not properly consulted. And I will say this whilst reading the statement, the press release from the government, which says the government has adopted a policy of engaging in a dialogue and consultation with all stakeholders in pursuing this goal. My ministry has been holding regular consultations with trade chambers, trade associations and professional bodies. However, this statement by the ministry was disputed by these gentlemen as well. So you agree that it is imperative, beyond imperative, that consultation with professional bodies before a trade agreement is signed?
Absolutely. I started off by saying that there's room for improvement in terms of the consultation process and in terms of communication.
I just want to make one point that I didn't say that we should encourage pirated software. It's not that I intended. But country like Sri Lanka cannot stand on its own unless the government supports. That support is given to Singaporeans some time ago by the Singaporean government. Therefore, they have their own software developed. So, without doing that, it's like we don't know how to swim, and they can swim, and both of us are going to jump and ask to swim.
Right.
So, this is what we are saying. Not that we are saying that use pirated software. Look at our professionals. What is their financial standing? So give us some support. The government should give us support so that we can improve. Then we are ready to fight.
Sure.
That is the issue here.
Thank you. Thank you very much.
From among the concerns that have been raised by the professional bodies, what really strikes out to me is mainly the concerns raised by the architects and the engineers. Who are among the detractors of some of the points in this agreement. You just heard Mr. Wijewardana's comments on software. That software is developed overseas, very expensive to purchase, and that in Singapore the government assisted in the development of affordable software for architectural services there. Do you feel that you mentioned investor confidence, that this agreement was also meant to inspire confidence in investors coming from Singapore by allowing them to have that sort of backup support? But do you feel that in the negotiation process, at least, a grave oversight has been committed by not taking into account what appears to be the legitimate concerns of the architects and engineers?
I think there are very, very valid, legitimate concerns that have been aired out by the professionals, not just my fellow panelists here today, but other professional bodies as well. But at the same time, it's important to kind of contextualize what has been said here. Pretty much everyone has said that they were consulted or that they went for certain meetings at some form or the other. And I'm not here, and I don't know what the exact consultation process is, so I'm not here to speak for the government.
On that subject, this is something that I've constantly sort of struggled with, hosting a business show myself, is that I constantly ask this question. Not only in Sri Lanka, around the world, there is when it comes to trade negotiations, there is a pronounced lack of transparency. These negotiations tend to always happen behind closed doors, and the lack of transparency breeds suspicion. Why is it that trade negotiations cannot take place in an open and transparent manner? What's the reasoning?
The biggest reason that it's a negotiation. because if some of the consultations are made public, or kind of the consultations or the outcomes of those consultations are made public, the other party or the other country that we're negotiating with will know what our domestic, what the domestic electorate wants in terms of exact certain industries and so on. So theoretically, I'm not talking of what happened with the Singapore-Sri Lanka FTA, but generally the reason why these consultations tend to happen behind closed doors, or that they are not made public as much as we would like, is because that needs to be compromised during negotiations, and in terms of making those offers to elicit a compromise, it's best that they keep some information to themselves, or the government, respective government, keeps that information to themselves. That's not to say that there shouldn't be any transparency at all. There is an absolute need for transparency during these negotiation processes, particularly in terms of consultation and taking in that feedback and so on. But there needs to be certain realistic framework within which that consultation happens, and which is why we see a lot of this kind of negative opinion about trade negotiations, not just in Sri Lanka. I mean, we saw this a lot with the TPP negotiations across in the Asia Pacific, is because of that. And the reason for that is negotiations and compromise.
Dr. Ranasinghe, I want to also ask you, now you mentioned about these explanatory notes. I hope you'll share them with me. I'm very keen to have a look at them myself. Is there any way in which, is there anything, the government has, the two sovereign governments, as Mr. Wijewardena mentioned, have already signed this agreement. As Mr. Aberatna mentioned, it has to be ratified by Parliament, following which it will come into effect, notwithstanding, of course, the challenge that the Bar Association of Sri Lanka has placed before the Supreme Court. Notwithstanding that, consider the fact that this agreement has now been signed. Assume that Parliament, hypothetically, assume that Parliament ratifies it. What is it that the government can do right now to address the concerns that you have raised?
Now, first thing is, actually, I just want to answer what my colleague said. Now, these agreements, government purposely make it I would say purposely hide this information from the general public, because Right to Information Act also allows that international agreements, if I can remember, there is an exception that you don't have to disclose for a period of 10 years, I think.
Section 5C.
Certain years. So therefore, this is in order to hide the proper information from the public. Now, as you said, I think engineer architect D.H. Wijewardena also discussed this matter. In order to balance even this situation, probably the government must support the professionals, especially in respect of software and various other things, because the progress or the efficiency of an architect or maybe an engineer who does a lot of designs work purely now depends on the software available, which is very expensive. So therefore, there should be subsidy on the software, especially for the professionals. And the other thing is, actually, when we are working locally, we are subject to local taxes. Various commitments are there. Now, for example, when you do a design work as a professional, there is something called professional indemnity insurance you have to take, maybe for a period of 10 years. But if a foreigner comes and do a design here, although there might be a commitment, he can always vanish from here, supposing if there is a problem in the designs. So therefore, all those things have to be looked into. There should be concessions given to the professionals. Now here, under the, I read you about the explanatory notes here. You can see the last explanatory note which is given here. I will, if you can give me some time, I will read here. In accordance with Article 7.2, the schedule shall not apply to subsidies or grant provided by a party, including government, supported loans, guarantees, insurance. So that means the whole thing is given to Singapore, and it is excluded from this agreement, where Singaporeans have that advantage as a domestic in Singapore.
Arnold, there's a Singapore side, no?
Singapore side,
Yeah.
that means actually from their side they are giving this concession, but there's nothing on our side.
Nothing, absolutely
So
nothing.
therefore we have to be protected by the government by giving concessions, and also taxing system of foreigners by cross-border. There is a serious lapses in taxing system in cross-border. I don't know how they are going to tax it, because they are finding it even difficult to tax the locals. So therefore that has to be looked into very carefully, because see, I know I have worked in Malaysia for some time. If you have work permit in Malaysia, and if you work for a short time in Malaysia, you can't even leave Malaysia unless you make a declaration and give all your income and taxes and clear everything. So something like that has to be introduced, so that you are playing in equal playing field.
Mr. Kapila Pereira, I have a question for you.
Yeah, Charita.
Yeah, now some of the concerns raised by the professionals are visa regulations, then accreditation of qualifications, then identifying professional shortfall, right, in the labor force. So how do you propose that the government address these concerns? It might be too late now, we don't know, but had you, if you had an opportunity to consult with the government, what would you have proposed?
Yeah, the thing is that first we need to know the labor shortages and the workers, the requirement of the professionals. As I understood that you are asking how to...
Okay, for example, let's take the IT sector, just take it as an example. How would you have proposed to address these concerns? These are some of the concerns listed by professional bodies as oversight by the government. What are your proposals?
Yeah, to improve the number of professionals here, because even if you go for this investments and everything, still we need the professionals here. So that's why I already asked that what are the initiatives that our government took to increase the number of IT professionals here from the government sector and from the private sector. We haven't done anything. For example, if we start that one 3 years back, and now after 3 years we will have graduates here. And for IT, you don't need lot of money, because it's not like medicine or engineering. You don't need lot of infrastructure, and the knowledge is not hidden, because you can get it easily from anywhere, and we have lecturers and everything. So only thing is that we are not providing those facilities in a way. Then we could have improved the number of professionals, and there are other professionals.
Is there a gap in terms of professionals, say high top tier professionals in the IT sector?
No, there is no gap in here. So we have enough professionals already today and
but
previously
there
as
has
well.
been a request from the IT sector itself to
Yeah, the thing is that ICTA is requesting these things, and it's a government body, and you know that ICTA is not competent enough, because you know that previous election what happened with that one, and you know that president's website was hacked once because it was not secured
But it's
enough.
not only ICT, even like other IT companies, like major IT companies have also been asking for liberalization, because the labor supply is not sufficient to meet the demand.
Is it true? That's the question, because that government, the ministry is saying that, Mr. Malik Samaravikrama is saying that these people were consulted and these consultations were considered, but it is not. And in the same manner, they are saying this, but are they coming up and saying that, okay, we requested to open or to liberalize this? Because these are all lies, a set of lies to hide the things what they are doing. So this is conspiracy actually. That's the
So
thing.
you are saying there are no labor skill gaps in the IT sector?
No,
There's-
no
okay.
skill gap.
Mr. Sunil Aberatna, can you tell us what would you have advised the government on addressing, say, for example, strict visa regulations, looking at examples of other countries, how they set about it, and how can the government look at a sort of a mechanism to accreditate qualifications?
Yeah. Before that, I would like to inform that we have to improve our legal education in this country. With the recent development of that international trade and commerce, to introduce investment law, information and communication technology law, international commercial arbitration, and construction law. So these are the developing areas in the country.
Yeah,
So
what you're
it's high time-
proposing might
yeah,
take
it's
a
high
long
time, yes, it's high
period
time
of
to-
time.
yeah.
But since there are other free trade agreements in the pipeline, what are the mechanisms that the government can look at right now?
Yeah, straight away they can recognize that who are the qualified the professionals, real professionals in the various areas. So then that, as you said, when it comes to the visa matters, of course they can immediately contact either that by association or that university grant commission or that whatever the place who maintain this database. With that, of course, that we can give the recommendation. That is one recommendation actually that we proposed at the discussion level to form the umbrella organization linked with that custom, linked with that immigration, that whenever this professional come to Sri Lanka, to contact the respective professional, and then we can find out whether the correct person is coming to the country.
Kitmina, what can you propose now? For example, accreditation of qualifications. Who in Sri Lanka can actually vet that process?
So I think there's a two-stage vetting process, and the most important stage are the companies. Why would a company hire someone who's unqualified? So because the company has to have them employed in that company for 1 year. Before that, they have to make sure that they were employed for 5 years professional experience before that, and then send them to Sri Lanka and base them in a Singaporean investment in Sri Lanka. So I think there is a automatic kind of checking mechanism where the companies themselves have an incentive to hire qualified people. But secondly, in terms of domestic regulation, I think this is a very genuine concern by my colleagues, is that there are certain domestic standards that are set, and if they are to, and those will kick in. So if you are practicing a certain service in Sri Lanka and there are domestic regulations, then if you find that someone is not adhering to those regulations, you can bring them to courts. You can bring those companies to courts. So I think there is a two-pronged mechanism. One, the automatic system where companies have an incentive to hire qualified people. But secondly, the domestic mechanisms on regulations that are already set in will kick in and be enforced through that. So the same way that a Sri Lankan national is checked that they adhere to certain regulations, a Singaporean national will also be held to those same standards and can be taken to, that's one of the reasons why there is a dispute settlement mechanism, where in a situation like this, it can be taken through the domestic judicial process, and of course arbitration is a last resort, and that has been set up as well. So I think there is both those mechanisms can be applied. Of course there are improvements that can be made, and I think that is something that has to happen domestically, and it probably should have happened years before. It's taken, if these were such important concerns, then they should have been addressed in years before this, and those need to be addressed in the future as well. But in terms of implementation, that's how it will work, both in terms of the company, but then in terms of the regulations that are set domestically and then through the mechanism.
Right, thank you very much.
One point that he raised, that at what price we want to go to courts, at what price? Do we have the same sort of financial standards of Singapore and Sri Lanka, when you go to courts to resolve disputes, whether we have the capacity to do it. And one thing that I think you raised a question on him, that how do you change these regulations, how fast you can do that. You have to fast track at least now, but mind you, when you sign a free trade agreement, you are not supposed to change certain things which affects the agreement. So we have a string there. That's why we say we should have done so many things prior to signing this. Now when you try to meddle with that, we can then always object. It is affecting our agreement. So that's the thing. But still, it's not too late to sort out some of the important issues.
Right. Thank you very much. Kitmina, would you like to respond very quickly?
Yes.
We are running out of time.
It's the domestic judicial process. So the same price that takes in terms of going through the domestic court process will be the same price in this case as well. It's only if there is no solution through the normal processes that we then move on to the international arbitration.
What can I say?
Yeah.
All right. We're going for a short commercial break. We'll be right back with the final round. Good evening. These are the final few minutes of Face the Nation. Thank you very much to the viewers who wrote to us, SMS'd us and sent us messages on Facebook. Your questions are duly noted and have already been posed to our panel of guests. Very quickly, let me start off the round of questioning with Mr. Sunil Aberatna, attorney at law, representing the Bar Association of Sri Lanka. Ms. Aberatna, the deal is done. The agreement has now been signed. The Bar Association is before court seeking for several orders citing grievances. What is the way forward? What measures should the government take in order to rectify the grievances that you say you are having as a member of the Bar Association of Sri Lanka, as an attorney at law of the Republic?
Yes, Sonali, now we filed this fundamental rights application because their action is not in order. They have not followed the correct legal procedure. On that basis, we have filed this action. Now, this is what we made our suggestion at the number of discussions to improve legal education, because this is a high time to introduce a new legal subject to curriculum of the universities as well as law college.
Ms. Aberatna, don't you think that the stakeholders in that enterprise are different in the sense that then it is the Ministry of Justice, the Ministry of Education perhaps, who need to come together with other varied stakeholders? This is an entirely different issue, don't you think?
No, this is the same issue because first of all that we have to improve the quality of our professionals. If this is the problem with the government to hire some professionals or professionalism from other countries, so what they say is because we don't have enough expertise. That is one area addressed starting from SIPA. So that is one solution. The other solution, I will now take another example. Sonal, you said Singapore is a arbitration hub. Who says that Singapore as arbitration hub? They who marketed Singapore as arbitration hub. So we also can create Sri Lanka as a neutral venue for arbitration. But before we sign, we should have amended our arbitration act. There is one clause that who can represent in arbitration. The parties by themselves, that the officers of the particular parties of the company or whatever it is, the representative is defined. Only attorney at law. Who is that attorney at law? Comes under our Judicage Act. So without amending that existing legal provisions, that we can't think about that Sri Lankans will get any support or benefit out of these agreements. So we have to develop our infrastructure. We have to bring some amendments to the Judicage Act, especially then Arbitration Act. Then only that we can implement this bilateral agreement.
But it's still not too late to amend the laws. And that is your...
Yes, exactly.
These are your closing remarks.
We are not against that bilateral agreement or tripartite agreements. We have to expose to the rest of the world. But we have to do it in proper way.
Right. Thank you very much. So... the call to action from the government is that the government needs to realize the importance of amending, reforming domestic legislation such as the Arbitration Act.
Exactly.
Right. Thank you very much, Mr. Sunil Aberatne, attorney at law. My next question is to Mr. Kapila Pereira, Secretary, Professionals National Front, representing the IT sector. You were very critical of this free trade agreement with Singapore. We've also seen professionals very angry and incensed at the ETCA, which is another agreement that is with India. We'll also be seeing a free trade agreement with China in the future. So essentially, free trade agreements need the concurrence, the support and the guidance of professional organizations. You are angry right now. What measures need the government take to calm you down? And I'm talking not to you as an individual, but as a representative of the IT
The thing
sector.
is that, yes, if we take India or China, without seeing the agreement, we can directly oppose that, don't sign agreement with India or China, because there are enough reasons and we can do the reasoning. We already did that. So, but with Singapore, we can go for a good agreement. We are not saying that don't sign agreements, or we are not saying that don't liberalize. But the thing is, we have to be tactful and we should be skilled enough when we are doing these negotiations. And are we, with my past experience and the things like this and everything, all the press releases and the government responses, that I am in the feeling that they are hiding the things from all the professionals, and just not only the professionals but all the associations and even the industrialists.
Mr. Pereira, with all due respect, that's an opinion. What do you have to say about the fact that the free trade agreements will bring about an increase in the country's GDP? It will create more jobs. There'll be taxation.
Yeah, that's why I was telling that, okay, with Singapore, even we thought that we can go for a good agreement. But in here that we have done a bad thing, and everyone has explained that one, because we haven't taken any measurements to protect our service industry. We just open that and we liberalize without thinking and without stepping it up. We don't have a plan there.
Okay, so now that the agreement has been signed, and in your opinion we need a plan, what does that plan need to entail? Very quickly, because we have government representatives watching us also.
Simply consider the consultation from these professional bodies, because we need to consider that one. Number one is that.
Right. Thank you very much for those closing remarks. Mr. Kapila Pereira, Secretary of the Professionals National Front, representing the IT sector of Sri Lanka. I move my attention to Mr. Kitmina Hevage, Research Officer at the Institute of Policy Studies. You don't seem to have a pessimistic outlook on this free trade agreement with Singapore. We will also, as a country, be looking at other free trade agreements in the future. Now, whatever mistakes that were made, unfortunately. However, moving forward, the government needs to take stock of the situation, of the grievances of varying professional bodies, and make sure that there are proper consultations taking place, that measures are taken to listen and implement measures that are brought out by professional bodies, by technocrats, by intellectuals, by civil society. Kitmina, how does, in your opinion, the government go about doing this?
And the first thing that the government has to do is address the communication gap that it has. They are not doing a good enough job in terms of communicating the positives of these sort of free trade agreements, what's included in them, what sort of reforms are taking place and so on. And this is not just the English-speaking community in Sri Lanka. I mean, the Tamil-speaking and the Sinhala-speaking community are usually left out of these discussions because these sort of technical discussions happen in English only. So I think the government has to take more responsibility in terms of communicating that. And one of the negatives of the consequences of this communication gap is a trust deficit. Because of this communication gap and the trust deficit, we are seeing a lot of falsehoods, or in new parlance, fake news being said about, that Bangladeshis and Chinese can come into Sri Lanka and work, and various other factors, misrepresenting what the facts of the agreement say. And that happens because of this communication gap and the creation of the trust deficit in turn. So I think overall, the government has to do a much better job in terms of communicating to the public, and in turn the consultation process as a result, particularly moving forward in terms of EDCA, the Chinese FTA and any other FTA that comes up in the future. There's a lot of room for improvement for that as well. And I think that there has to be constant dialogue between the government and the consultations with the professional associations, the industries and everyone else involved, and particularly the public, in terms of what is included, why the government is doing certain things. Because after all, like I said before, all free trade agreements or all trade agreements have winners and losers. The issue is that most of the winners are silent. The losers are the ones who are most vocal and are able to kind of get together and kind of make that and create and come into that trust deficit and make use of it. So in terms of that, it is important and imperative that the government makes sure that the public, the general public, understand that on net that there is a positive impact of these agreements to the public.
Thank you, Mr. Kitmina Hevage, Research Officer at the Institute of Policy Studies. I move my attention now to architect D.H. Vijayawardena, President, Sri Lanka Institute of Architects. Mr. Vijayawardena, you were also very vocal with regard to your stance. You said that we need an equal playing field, and you asked the government to help the professionals. What are your closing remarks? We need to, as a country, move forward now that the agreement has been signed. What measures should the government take to work in collaboration with the architects to ensure that the country moves together?
Yeah, very simple. We had a good dialogue and we should continue. That dialogue, we can't, after continuous dialogue, we can't stop halfway and go and sign the agreements. There's no point. So this dialogue should continue. And it can be fast-tracked. We are ready. And I don't know, the agreement already been signed. I don't know what happens when you go to courts, because sovereign nations have signed agreements. We saw what happened to Port City. Finally, we had to agree. But what we are saying is, at least now, the negotiating people should know what they are doing, should consult respective professions and the people of the country. What is lacking in this country? Just because we sign agreement, I don't believe the investment will come. It will never come like that. Investment come in certain reasons and certain backgrounds. So therefore, what we are saying is, the negotiation team must have proper people who look at various tools in these agreements and use them for our benefit. Maybe they may not agree, but that is negotiating. That you must have the negotiating power when you go there and negotiate to get the best out of it. Now, when you look at this drawing, whatever my friend says, look at this. I am telling, just look at the Sri Lankan side. It is empty. It is empty. Why we don't have learned people here? We have. They have not been consultants. Some people think they know everything, and they just go there and give a blank sheet. Why does the Singapore side is full of so many things? Because they know what they want. They know what they want from out of this document, and my friend said they are making 19 billion as advantage of this document. Similarly, we should have said we are getting 20 billion advantage out of this agreement. We had to say why, how we are getting that. That is because our negotiation teams are just gone there and just they haven't done their part. These agreements are good, these trade agreements are good, provided we focus and get maximum out of it. At least now, we are ready to come, we are ready to support the government to do those things, at least for the next. I think my colleague Anand will agree. We agreed that we are ready at any time to discuss and sort out. We don't have to see the one-to-one the document. I know that there are certain secrecy must be there, obviously. But we have to tell, then they go and look at both sides. But that never happened. So at least in the future, let's do it.
Great. Thank you very much. So your call to action to the government is continued collaboration and negotiation in the proper manner. Thank you very much, Mr. Vijayawardena. My final question is to Dr. Ananda Ranasinghe, past President and Council, Institute of Engineers of Sri Lanka. Well, looks like you have the final say on this panel. Dr. Ranasinghe, you stressed some very important points, saying that we need to look at subsidizing, we need to look at taxation for foreigners, and we need to really help the professionals. So the responsibility of doing this rests primarily in the government. What call to action should we then ask for from the government?
Now the most important thing is actually we can't be, now Kitmini said that there have to be winners and losers. Now we can't afford to lose. Singapore can afford to lose, but we can't afford to lose. We have to be winners all the time. First serious mistake, which still I don't think my colleague Kitmini has realized, that selection of workers have to be not done by the organization but by a learned body separately. Now, for example, that is why doctors are very concerned. Now, let's say for a hospital project, when they are running a hospital project, if the employees are selected by the employer, how about their quality? Basically what they do is they go by the salaries of the employers. That is what has happened in one of the BOI projects, where they have gone only on the salaries that they have to pay, but not on qualifications. The purpose of Engineering Council Act, which was passed by this government, is basically when you are practicing as an engineer, you have to register as an engineer, and the qualifications have to be assessed by a professional institution of engineers. So therefore, I think the entire concept of this agreement, where Singapore has done properly, they said even a professional who is going to work in Singapore might have to sit for an English language examination. So let's say if a professional is good, they can always say is not skilled in the language, because they have taken it very seriously, and also they are going to have a greater control on the person who is going to work there. But in our agreement, as I think you also have read, that a person who has worked for 5 years, now who is going to decide on these 5 years? The thing is, actually I may have worked for 5 years as somebody, but does it mean I am suitable for working? So qualifications have to be assessed. That's the most important thing, which is not in this agreement. So therefore, that has to be looked into. Still, I don't think this has been realized by, although this has been vetted by various people, I don't think that has been realized. So therefore, and the other thing is actually preconditions or explanatory notes, as I mentioned earlier, covers the entire agreement. Although there are clauses here, you can have one clause here and cover the entire thing. So therefore, the entire agreement has to be looked into, not in piecemeal. So there might be one clause which we might have an advantage, but it could be, I would say, it could be nullified from explanatory notes. So therefore, this whole thing has to be studied. This cannot be done by only a selected group of professionals, like, let's say, I am not sure, economists or whoever, experts. since this is concerned about the professionals in this country, it has to be studied by all the professionals, including lawyers, architects, etc. So therefore, I think the other serious mistake is actually, although we had on and off consultations, no proper consultations have been done, and until this was prepared and signed, we were not aware of it. Therefore, that has to be done in order, at least in the future, to have proper agreements. Thank you.
Thank you very much, Dr. Ranasinghe, for your thoughts. Very quickly, let me thank our panelists. Mr. Kapila Pereira, Secretary, Professionals National Front, representing the IT sector. Architect D.H. Vijayawardena, President, Sri Lanka Institute of Architects. Thank you for being on our show with us this evening. Mr. Sunil Aberatne, Attorney at Law, representing the Bar Association of Sri Lanka, one of the key stakeholders in this enterprise. Thank you, sir. Also, Dr. Ananda Ranasinghe, past President in Council, the Institute of Engineers, Sri Lanka. And finally, Mr. Kit Minahevage, Research Officer at the Institute of Policy Studies. For asking all the questions that needed asking, thank you, Charita Fernando and Nadeem Majid. Well, that draws to a close this edition of Face the Nation. Now, in any trade liberalization process, there can be negatives, there can be positives. The government's responsibility is to ensure that the correct information is filtered down to the general public so that their fears are allayed. The responsibility of the government also is that proper parties are consulted before agreements are signed, during the negotiation processes, and that the consultations are taken into consideration when signing agreements. So lots to look forward to. The free trade agreement between Sri Lanka and Singapore, which was signed in January 2018, was the topic of discussion this evening. We looked at the pros, the cons, and the way forward. All our panelists came up with a call to action from the government. What they say mainly is that there needs to be a level playing field, that professionals need to be consulted, and that they are willing to work collaboratively with the government. Thank you very much for joining us on Face the Nation. Good night.